The Personal Injuries Assessment Board, which changed its name to the Injuries Resolution Board in 2023, was established by the Personal Injuries Assessment Board Act in 2003. The Injuries Resolution Board, formerly PIAB, is an independent Irish state body that assesses personal injury claims. Personal injury claims can include motor liability matters, public liability matters, road traffic accident matters, work accident matters. The Injuries Board is an independent state body, is not a court, has no judicial function, and applicants are not required to attend at the Injuries Board to give evidence. Medical assessment form. The injured party must submit medical assessment form or a medical report as part of their application to the Injuries Board. This medical assessment form must be completed by the person's medical practitioner, which forms part of the application. Form A, the applicant must also submit as part of their application to the Injuries Board the standard application form. Form A is the name of the application form and is a detailed document issued by the Injuries Board to the injured party. It can be found on their website. Applicant fee. The applicant must also pay the sum of €45 or €90 as an application administration fee to the Injuries Board for the application, and this is dependent on if you submit your application online or via post. Once the application forms are submitted with the application fee, the Injuries Board will proceed to register your claim under Section 50 of the Personal Injuries Assessment Board Act 2003. One has, within 2 years from the date of the accident, to have the case lodged with the board, or it is statute barred if no exemption applies. Section 13, Notice Personal Injuries Assessment Board, Act 2003. The Injuries Board will then send this notice of the application to the alleged wrongdoer, and he/she has 90 days to consent, reject the Injuries Board assessing the matter. The cost for the respondent party is a €1,200 administration fee. If the alleged wrongdoer agrees to the Injuries Board assessing the case, the Injuries Board will proceed to assess the case. If the alleged wrongdoer rejects the Injuries Board involvement, the board cannot engage in the matter, and the injured party can proceed to court if they wish to proceed with their case. Special damages. The applicant will be furnished with a certificate of loss of earnings and a form regarding special damages. 9-month period. The Injuries Board must make their assessment quantum of damages, if any, within 9 months of receiving the alleged wrongdoer's consent to assessment. Once the assessment decision is made, the alleged wrongdoer is given 21 days to accept the award, or it's considered acceptable. The injured party is given 28 days. PIAB order to pay. If the injured person and the other person, respondent, both accept the award, then the Injuries Board will make an order to pay. If one party does not accept the award in question for whatever reason, then no order of pay will be issued by the Injuries Board and the person can proceed to court to a decision. Damages can include medical expenses, loss of earnings present and possibly future, damages for belongings and for pain and suffering. The judicial guidelines established under Section 18 of the 2019 Act, which catalogue the level of damages for this type of matter which can be awarded. We assist clients with cases from the start to finish, preparing and submitting the PIAB application, gathering evidence and expert reports, representing our client in court, if necessary, and dealing with any negotiations. If you have any questions, our contact details are 01 54611121 or 052 612 1999, or our email address is info@clearysolicitors.com, personal injuries. In contentious business, a solicitor may not calculate fees or other charges as a percentage or proportion of any award or settlement.